Now, on the next one, remember that was the first exception. The second exception to the at-will rule was retaliation. They can't retaliate against you for you doing something you have a protected right to do, like complain about discrimination. You have a lawful right to complain about discrimination. You have a lawful right to do a lot of things. And if they fire you for those reasons, they are in trouble. Now, for example, this guy right here says, you know, I really respect the way you spoke up when they asked for your opinion. Now, if his opinion was about discrimination in the workplace or illegalities, fraud on the IRS, or whatever it might be, he's got rights as a whistleblowing employee. And he may be looking for an employment ad, but he should also be probably looking for an attorney to pursue his rights, because he does have a decent claim. Okay, retaliation. Now again, it's not any old retaliation. You've got to have certain elements in this. You have to have a good faith belief in or an actual violation of law. Now, it doesn't mean that they're actually discriminating or they're defrauding the IRS or something like that. But if you have a reasonable belief that that's what they're doing, and you complain about it, and they retaliate against you as a result, you have a case. So you have to complain. You don't even need to complain. You can refuse to break the law or to work according to law. You know what? I'm not driving the truck without taillights. And you refuse to do it, and they fire you over it, you have a case. Or you just have, like, you refuse to drive it, and they want you to drive without taillights, and they fire you over that, you have a decent case. And retaliatory acts by the employer. That's what it takes. Okay, next category would be contract liability, where the employer has made promises to you that overcome the at-will presumption. For example, express contract. You might have either an oral express contract that they're going to be fair, that you can work there for 3 years, and that would overcome the at-will presumption and require good cause. Remember the conflict, at-will versus good cause? There may be even nothing in writing, or nothing definite, but you might have an implied contract that says that they'll be fair with you. And now you look at maybe 4 elements when you want to see if there's a decent enough of an implied contract to give you these type of rights, such as duration of employment. The longer your employment is, the more that you can presume that there's got to be some element of fairness in this relationship, that they've got to have a good cause reason for firing you. Usually 5 years or more, but even if it's less, you can still argue that it's long enough. Employers' policies and procedures. Maybe in their employee handbook it says, we'll follow a progressive discipline policy, and we'll give you a warning before we do anything else, and we're fair, we have the open door, we're just like family. All these promises like this imply a fair procedure, imply that they're not going to fire you because of your shoelaces, and that they're going to have a decent reason and maybe a little bit of notice to you. Assurances of continued employment. They just put you on the stock option program. They put you on the retirement plan. Said, hey, we hope you're here until retirement. All these are promises that imply that they're going to be fair. And industry standards, some industries naturally have these type of agreements, and it's implied by the nature of the industry. Other types of industry, it's not presumed as much. So anyway, those are the big 3 on the exceptions to the rule of at-will. So essentially when you're talking about wrongful termination, wrongful demotion, failure to promote, you're talking about the concept that the employer can do whatever they want as long as it doesn't violate law, with the 3 exceptions of discrimination, retaliation, and breach of contract. If you come within one of these 3, then you can argue you shouldn't have done it, and it had to have good cause. Now there's a lot of, and that's the main discussion of wrongful termination. Now we shift over to related claims. Now before I go any further, any questions on that so far? And I'll go to related claims to wrongful termination. Then I'm going to come back eventually to some of your specific questions and answer those to make sure I covered it during the discussion, or I'll keep going on that. Okay, now let's talk about other claims of wrongful termination, besides wrongful termination, that you could make. Okay, there's a long list here. such as libel and slander. In the workplace, sometimes the employer says bad things about you that aren't true. Or blacklisting. After you leave, they tell your next employer, a prospective employer that calls them, oh, this person is a worst employee in the world, we had to fire them, they aren't a real worker. I mean, you're never going to get a job if that's happening. And so you may have real rights against the employer for saying these type of things, but you'd have to show that it was untrue, that they meant to, they're intending to harm you. And then you could have all sorts of rights against them and to make them either make them stop it or recover money because of the harm they caused you. The assault and battery, sometimes this happens. Sometimes not big fights, sometimes fights do occur, but the old situation of the boss, male boss, giving a massage to the female secretary, or shoving people, or sometimes assault, or throwing things at you. You're so mad you throw it down and you hit somebody. I see that a lot with a lot of my clients. So you might have a claim for that. Actually, that's a criminal claim as well, besides being a civil claim. Okay, then we have fraud. Now, we talked about breach of contract, failure, not fulfilling your promises. Fraud is a little bit different than breach of contract. Fraud is, oh, I promised you this, and whoops, I just didn't get around to doing it, or things changed, and I couldn't do it for you, or whatever. That's breach of contract. Fraud is a little bit different. Fraud is, at the time I promised you, I never intended to fulfill it. From day one, I never had any intention of following through. That's fraud. And the reason fraud is better than a breach of contract right is because breach of contract, all breach of contract gives you is out-of-pocket losses, wage loss. That's about it. Fraud gives you wage loss plus emotional distress. Oh, it affected me emotionally. Plus it gives you what's called punitive damages. That not only your real damages, but slap the hand of the employer type damages to teach them a lesson. That's punitive damages. And that's what scares employers. And you have that right to have that type of claim if you get it into the fraud category. And for that matter, if you get out of contract and you get it in the discrimination or retaliation category, those are called torts in which you have this right of punitive damages and greater types of recovery. And it's a much more powerful claim. Okay, fraud to move, this is when they deceived you. Come work for us, move from New York, come here, join us, and we'll give you a Cadillac, and we'll give you the Beverly Hills district of sales. Sounds good. So you move here, and I give you a beat up Volkswagen, and I assign you a Corona or something. A little bit different than Beverly Hills, and you're all upset. And then you intercept the memos, and and somebody else would be given the assignment for Beverly Hills and given the Cadillac before you even left New York. I mean, that's proof of the fraud. And sometimes you have that type of proof. And if you can prove fraud, you can get double damages, plus it's a crime. It's that serious. The legislature thought it was so serious, they allowed you to recover those type of things if you can show fraud. Workers' compensation is if you're injured on the job and you can't work, or you can't work as much as you could work before, you get money. And it's all part of your other claims you might have. Invasion of privacy, they're going through your purse without your knowledge. They're disclosing your medical history, your records to other people without your permission. All that's invasion of privacy. You have a claim for that. Emotional distress, false imprisonment. You're not leaving this office until you sign the settlement agreement. You got 2 football players at the doors. That's false imprisonment. That's actually a crime. It's illegal to do that. Negligence, non-termination wrongs, breach of contracts during the course of employment. Sometimes you have a case within a case. You might, or three within a cases. So you might have a case for failure to pay you your vacation pay when they fired you. That's a case all by itself, plus penalties. Then you have a case for the act of termination, which might be discriminatory or retaliatory, a wrongful termination type thing. Then you might have a case for discrimination during the course of employment, whether or not the ultimate termination was justified. Then you might have a case for the inception of the employment, when they defrauded you to come there in the first place. So you might have a case and a case and a case and a case. So even if you can't prove one, you can prove the other. So you have to be aware of all that. Okay, other types, and then when you evaluate a case, you're going to want to understand what's important to an attorney in looking at any type of employee rights. What is an attorney looking for? And so think about that in your minds and saying, how would you answer that question? What do you think is important to an attorney Don't answer me yet, but while you're thinking about that, I'm going to cover that in just a second. Before I do that, I'm going to talk about damages. What are your damages in a case? And which is very important. Not only your claim for liability, can you prove your case, but, and that's kind of the brains of a case. Can you prove it? What's this? The heart of the case. This is how many tiers there are in your case. And tiers meaning what your damages. Were you in a mental hospital for 6 months because of what they did to you? Did you go to a doctor? You were sick to your stomach? You were out of work for a year? And all that's involved in that. So you've got to look at your damages. So we're looking at usually wage loss, your past and future. We try to guess into the future what you need. You get this whether you have a contract claim or a tort claim. Emotional damages, the stress that you suffered, your attorney's fees, you might be able to recover under either theory. Punitive damage, you don't get in a breach of contract claim, but you do get it in a tort claim. It might be based upon the net worth of the defendant. So if the company is about ready to file bankruptcy, you don't have much of a case. But if they're IBM, you might have a real good case. It might take a lot of money to teach them a lesson. Requires bad conduct for the social good, and that's how you evaluate punitive damages. Continuing, you might have multiple damages. Like I said, fraud to move, you get double damages. If it's a blacklisting type situation, you get triple damages, and plus it's a crime. Criminal penalties, that's a powerful claim. If what the employer did was so bad that they could go to jail for it, that is a significant wrong, and you might be able to recover, your ability to recover money from the employer goes way up if it's that wrong. In interest money and extra wages, you might get because they're failure to pay on time. They're supposed to pay you right when they fire you, and not after. Okay, how do you prove your case? It might be your word against theirs. That might be good enough. After all, if it's yours against the bosses, who's the jury going to believe? Sometimes the little guy. They're going to believe sometimes the big, rich employer or a supervisor. Documents, employee handbook, help. Any witnesses, circumstantial evidence like Perry Mason, looking for this or that, and a footprint, or you've got to look at other things that show a double standard. Are they treating me the same way they treat other people? Adverse impact. It seems like they're firing all the older people, whether they intended it or not. That's the effect of it all. A pattern of conduct. Well, they've been doing illegalities for years now. It shows that what they did with me follows their same course of action. Peer comparison is very important. Okay, so when you're looking at a case like this, I'm going to put a couple things up here. What are you looking for? Now, most attorneys are going to be looking for about 4 different factors in evaluating the case. And the first factor is liability. Obviously, that's the most important factor.